Judge, the testimony was clear for my client and also his daughter, that and his wife, that they went there with the intention of his wife mailing a package out. He did not intend to film that day. That was not their intent. The testimony was clear. If he intended to go in there if he meant to go in with the intention of somehow filming and causing a disturbance, he wouldn't have waited in the car. He only came in once there was an issue with his wife. His daughter had to come get him, and at that point he came and he started filming. He was not aggressive. The most clear evidence of this entire thing is the video. He voiced his opinion on the situation, which is a First Amendment to do these. They're government workers. As a post office, they're federal employees. He has a right to address his grievances with them. He wasn't being loud. He did not disturb any of the customers, as Miss Turk, I believe her name was, testified. She was the one working the desk. The video clearly shows that she's still helping the individual who left, while my client was back behind the island. He didn't approach when any customers were there, but he was having a conversation with the other worker who was behind the desk at that time. There was a lot portions where my client was walking around filming. He was not getting into any customer's way. I believe there were a total of 3 customers on the video. Clearly, he never got in their way. He never spoke with any of them. He never prevented them from conducting their business and leaving. He did stay around after he spoke with staff after they told him that the police were called. The state just stated in their closing that his wife made a comment that, "Are they coming or are we just wasting our time?" That could also be construed as they knew that the police were coming. Are they coming or are we waiting around for nothing? It doesn't mean that there was some intent for the police to come. It just, she said the police were coming. Are they coming or are we just standing around waiting for nothing? That's more likely what happened based on just looking at the video. Miss Johnson also testified, who works at the post office, that it was cleared up with her after this, that people do have a right to videotape, and their policy is that people are allowed to film in the public lobby. My client, everyone who testified today that worked at the post office, my client included, who testified, stated that he never went anywhere except places that were publicly accessible. The video clearly shows that he was never overly aggressive. He was following around having a conversation, but he wasn't screaming at her. He wasn't yelling at her. He did make a comment that you're going to get educated today, but that's after they said, "Will you stop filming?" and he said no. The next conversation after that was, "Okay, we're going to call the police," and he said, "Okay, call the police. You're going to get educated today." Any reasonable person would not take that as a threat, but would mean that somehow, the police are going to come and give some type of information and you'll get educated. No one in their right mind would ever think that the comment that you're going to get educated today, some type of threat or, as the state said, bodily harm. That makes absolutely no sense. It's not reasonable that any reasonable person would ever even think that. And just to go through each count separately, just to make it easier, in counts I, and I were all for resisting. The video clearly shows that officer testimony from Officer Brox that they never informed him that he was being placed under arrest. The video clearly shows that he left after he left the building. He got Officer Brock's badge number. He continued to say, "I'm leaving. I'm leaving." He turned around to get the other 2 officers' badge numbers who were right there. Officer Brox then said, "You're not leaving," and then immediately went hands-on. At that point, the phone got turned off, and so we didn't have the portion after that. But Officer Brox clearly stated that she did not say that he was under arrest. They wound up on the ground where the camera of the second video picks up where he's clearly complying with the officers. He's laying on his chest. The officers are on top of him. He's calmly telling them, "Okay, I'm complying. I'm complying. I'm putting my hands. I'm not resisting. I'm not resisting." He repeated that. He was speaking calmly. He wasn't speaking frantically. He wasn't trying to get away. The video is clear on that. As far as the statute goes, it has to be that the person knowingly was under arrest and that my client was not consciously aware and did not gain that awareness in the few seconds that the officers made contact with them. Once he knew that they were arresting him after he fell to the ground, he had to brace himself. After that, he complied on the video and it clearly shows that he was complying with the officer's request to put his hands behind his back. Under the statute of knowingly has to know that he's under arrest, and with the state's or with the officer's failure to tell him he was under arrest and then just jumping on him and taking him to the ground in those few seconds, he was not aware and would not have even been able to comply. Once he was on the ground, he did comply, as the video clearly showed. In the alternative, the court did determine that he resisted arrest. Having 3 separate counts of resisting arrest in a situation like this does not comply with the rules of one action, one charge. This would come out of the People vs. Floyd case of Chicago, 663 N. L. 274, which had a case where there were multiple resisting arrest charges for different incidents of the same arrest. However, in that case, which allowed that it wasn't simply because there were a certain amount of officers conducting the arrest where the person resisted. It was that, in that case, it was an arrest where the defendant was physically fighting with the police and trying to avoid arrest, which took about 15 minutes, and based on the number of officers, the long length of time between the initial contact where he was initially arrested resisting move closer to the patrol car where he's resisting again and then also resisting trying to get into the car. It was not based simply on that there's a certain number of officers. It would be unreasonable to say that the number of charges to find someone guilty for resisting arrest would be determinate on the number of officers there. So if there's 5 officers, he's guilty of 5 counts of resisting arrest. That's not reasonable. That's not what case law says, so that shouldn't stand either. Count IV was criminal trespass to real property. As the state just said in her closing that it's the residence of another. Both the trespassing counts are 4 in the charging document are criminal trespass to real property. Under the statute, give me 1 second, Judge. Oh, here we go. Sorry, my client was charged under criminal trespass to real property with the state already just stated in closing a residence of another. This was a public building, so neither of these statutes actually even apply, so on their face they'd be invalid. He was charged under 720 ILCS 521-3, criminal trespass to real property. The very last subsection of that statute also states, for purposes of item 1 of this subsection, this section shall not apply to being in a building which is open to the public while the building is open to the public during its normal hours of operation, nor shall this section apply to a person who enters a public building under the reasonable belief that the building is still open to the public. I believe the appropriate statute that he should have been charged with, if this even applied, would have been 720 ILCS 521-5, which is criminal trespass to state-supported land. That statute is different than criminal trespass to real property because, criminal trespass to real property, there's a lower standard needed to trespass someone off the property. Under that statute, someone just simply has to inform them that they need to leave the property because it's privately owned land, so there is a very low standard to remove someone from your private property and private residence. On state-supported land, however, it requires that there's some type of interference with the IT, requires an interference with another person's lawful use or enjoyment of the building or land of the public. He was in charge of the statute. He was only charged with the other statute. We don't believe it applies. Even if it did apply, my client was undertaking a constitutionally protected and fundamental activity of freedom of speech and the right to film public officials in the course of their conduct. This was an established law in Glick vs. Glick, G-L-I-K, Cunniffy, C-U-N-N-I-F-F-E, which is 655 F. 378. The right to record or film cannot be exercised in a way that impedes public officials' ability to perform their duties. However, it's a fundamental right. He never impaired their duties. Clearly, on the video, it shows that he was voicing his opinion but never physically interfered. A CLU vs. Alvarez. It's a Seventh Circuit case which affirmed Glick and said the act of making an audiovisual recording is necessarily included within the First Amendment's guarantee of speech and of press as a corollary of a right to disseminate and the right to disseminate the resulting recording. So it doesn't matter if he didn't intend to go into the building, but even if he did with the intent to somehow disseminate the video, it's still a fundamental right that is protected. One moment, Judge. Count IV is a criminal trespass to real property, which states that after being told by employee Stephanie Johnson to leave the building is a violation of that chapter. Simply being told to leave the building without some other reason or interference is not sufficient under this circumstance being its public property. Exercising your First Amendment right to film or free speech is not sufficient to remove someone to trespass someone from public property, because if it was, it would stifle and suppress the First Amendment rights and would be arbitrary and also open them up to restrain issues. Count V also criminal trespassed to real property that he stayed on the land, remained on the land of the post office, after being told by Officer Brox acting under the direction. So the first count has to do within the building, and the second count has to do with outside the building. In the alternative, if the court does believe that my client was trespassing at the time, 2 counts of trespassing would be inappropriate, as the evidence already shown my client willingly left inside the building. When he was outside the building, he was leaving. He kept repeating he was leaving. He simply turned around to ask the other officers their badge numbers. He did get Officer Brox. The other 2 officers were right there behind them. He turned around and asked them their badge numbers, and immediately Officer Brox jumped on him, never told him he was under arrest, and just said, "You're not leaving," and they took him to the ground. He was on his way out. There was not a time limit. He wasn't trying to get back into the building. He was moving towards them. He was just trying to speak with the officers. He was on his way out. He just didn't get the opportunity to buy Officer Brox. Count V is criminal trespass to real property in that he remained on the property of the post office after being told, "Oh, sorry, I just did that one." Count VI is disorderly conduct in that defendant knowingly acted in an unreasonable manner as to alarm and disturb Stephanie Johnson as he continued to record employees and patrons. So Count VI disorderly conduct has to do with just simply the fact that he was recording. It can't just be determined that simply recording is somehow unreasonable. Under disorderly conduct, the main part of the statute is that this person's actions were so unreasonable as to cause a breach of the peace. Fundamentally protected activities, legal activities, cannot in and of themselves again. If simply one person is somehow alarmed that it's unusually that they're being recorded, it does not just automatically arise to the level of breach of the peace simply because one person or multiple people are alarmed simply by the fact someone is filming. The actions have to be unreasonable. People do not have a sorry, excuse me. People do not have an expectation of privacy when they're in public. If someone's allowed to be in public and they can see it with their own eyes, they can film it. So Count VI doesn't apply as all he was doing was recording. There's nothing else alleged in Count VII. Count VII disorderly conduct in that the defendant knowingly acted in such an unreasonable manner as to alarm and disturb postal employee Stephanie Johnson and to provoke a breach of the peace in that defendant acted and threatened in a threatening manner and said to Stephanie Johnson, "To get educated today." Count VII is based solely on his words, "You want to get educated today?" No reasonable person could take that as a threat. He's simply talking, he's simply discussing his First Amendment right to film. And if you look at the totality of the circumstances surrounding that entire conversation, it's not unreasonable to make a comment like that. It was not a threat. It was not intended as a threat. No reasonable person could take that "you want to get educated today" as a threat. Count VI is based solely on that, which he has a First Amendment right to say. He wasn't overly loud. He wasn't screaming. He wasn't swearing, therefore we don't believe Count VII is sufficient beyond a reasonable doubt either. Final count is Count VIII, another count of disorderly conduct in that the defendant knowingly acted in such an unreasonable manner as to alarm and disturb postal employees and to provoke a breach of the peace in that said defendant after being told to leave, followed and approached employees, and disrupted their interactions with patrons at the post office. The video clearly shows that my client was walking around calling when he was and all he was doing was having conversations with the staff at the post office. He never interacted with any of the patrons. He never got in their way from conducting business. Miss Turk, who first testified that she was the one working the front desk, and when asked if she was still able to conduct business and get the customers out of there, she said yes, she was able to do that. The only time my client followed anyone around is when they were having conversations. He wasn't overly aggressive with them. He was simply voicing his opinions on the matter and having conversations with the employees. He was not swearing. He may have been loud, but he was not aggressive. He didn't go running at them. He didn't go swinging at them. Nothing about his conduct was aggressive. So based on that, we don't believe that Count can be proven beyond a reasonable doubt either. As far as everything goes, Judge, in a nutshell, the video is the best evidence of the entire interaction. The court can see that clearly he was complying with police. He was allowed to be on the property. They can't trespass him off of a public building like that, even though he was leaving. He was trying to leave, and none of his actions can even be deemed disorderly under the circumstances of the statement, or the filming in and of itself, so we believe that the state cannot prove any of them. Allegations beyond a reasonable doubt. Thank you, Judge.
All right, thank you. State, anything in rebuttal?
Yes, Your Honor.